Good morning, Remax Distinctive, Dan Bouchard again, and we are talking today about dual agency situations and risk management. This is going to be a case study that was actually brought before an E&O claim. And it is actually the details of it are commercial in scope, but it applies in our situation too. So just take the facts that are presented here and apply them to a residential situation as best you can. And let's think of it in terms of a similar kind of residential scenario. And when you're thinking about this, and so that we can apply it and think while we're reading through it, think about the things that other things that could have gone wrong and things that could have been prevented, and we'll talk about it after the case. All right, a real estate agent agreed to list and sell a multi-million-dollar apartment building. The listing included an existing contract between the owner and a company leasing both one apartment and a large section of the roof for cellular communications equipment. The agent quickly had an interested buyer, so he agreed to enter into a dual agent agreement to facilitate the transaction. The buyer submitted a $3 million deposit. The problem, the agent had a long-term working relationship with the seller as a leasing agent for the building, but was unfamiliar with the buyer until this deal. The real and perceived amicable relationship with the seller would later create an issue as to whether the transaction would succeed as the market began to turn. The mistake. The agent had written several letters about the lease during the escrow period that clearly favored the seller over the buyer. The buyer believed that the lease created a title defect, but the agent, on behalf of the seller, incorrectly informed the buyer that action was taken to cure the defect and that he, the purchaser, could buy the communications company out of the lease after closing. The result, when the buyer experienced financing difficulties in a deteriorating market, he decided to declare the seller in default for not curing the title. In response, the seller declared the buyer in default for failing to perform. Each party laid claim to the $3 million earnest money deposit. The buyer and seller eventually settled, and the buyer received $2 million. The buyer sued the agent for the difference by citing the previous seller favored letters as the primary reason for the failed deal. Following document production and depositions in the litigation, the evidence revealed that the agent was in fact favoring the seller over the buyer in violation of agency law, with the buyer having several brokerage experts lined up to testify accordingly. The case was then resolved for six figures when potential experts for the agent came to the same conclusion. So, the E&O insurance provider writes that the prevention method of this was agency or breach of fiduciary duty allegations typically arise following a problem with a transaction. That's how these things start. It's not a problem until it's a problem. Many of these disputes involve claims of undisclosed dual agency. Keep that term in mind as you're thinking about this, undisclosed dual agency. Although ethical codes mandate agency disclosure, laws governing this issue are different in each state. You should be familiar with agency laws in your state to minimize the potential for claims alleging breach of fiduciary duties. Fair and equal treatment to both sides of the transaction is an important part of those duties. Fiduciary duty disputes often involve claims from undisclosed dual agencies. Learn from this real estate agent's mistake and be sure to familiarize yourself with agency laws in your state to minimize your risk. So who's got some comments about the scenario here or questions and let's kind of vet this out a little bit. Anybody have any thoughts or comments on this? Nobody? So
Um,
one
I was on
I'm not a
mute.
fan of dual agency. I think it's just setting us up for a lawsuit.
Yeah. there certainly are some risks in it. And so the key takeaway here is for the reasons that Meg just said, the key takeaway is it's very, very easy to unwittingly, not even intentionally, but unwittingly getting yourself into a favored situation with one side or the other. And that's exactly what happened here. So, and so that is the risk. The risk is in the gray area. It's not in the clear things that we do or don't do. It's in the gray area with the unintended risks. A lot of times that's where the problem kind of comes in. Anybody else have any additional thoughts? What else could have been done here? If they were going to be in a dual agency situation, what could have been done to mitigate some of those circumstances? Anybody have ideas?
Have both parties
So have put some parties sign what?
sign that they, the dual agency, a dual agency addendum or agreement.
Well, they probably did. That wasn't covered in here. They probably did some kind of dual agency like that. They probably did follow the state's guidelines. Um,
My
but
curious part is what were these written several letters to and from?
yeah, yeah.
And
I
they're
think
written.
I
What
think
what is that?
having a statement to really, I think the first thing that really needs to be done is to make sure that you understand that the client understands that you cannot take a preferential side,
Right.
and that first of all that a broker like myself or Andrew can step in for either side if they're feeling that they have questions that aren't being answered. And number one, offering that to the clients is often a good way to mitigate the loss, the potentials here. That's one thing. Another thing is making sure that the clients on both sides understand that they can seek legal counsel and that they should seek legal counsel if they have any questions or doubts about any of this. So, and making sure that that is communicated to them and documented, perhaps in an email, and citing it that way. Um, that would mitigate but not prevent the situation from happening.
Hey, Dan.
Yes, go ahead, Tim.
Hey, my thought is that any of those communications that were sent out, should have had a,
A clause.
disclosure at the beginning of it that they're, they're communicating with them, but they're doing so as an impartial, representative of the contract, or something
Yeah.
to that effect.
Or
Yeah.
copy both of them?
Yeah. And I would keep as much of the conversation that you can with doing both sides simultaneously.
Yep.
Because if you're going to be doing one conversations with one side but not having it with the other side, you're
Yep.
automatically setting yourself up there.
Yep.
So if you can't say it to both sides simultaneously, then you probably shouldn't be saying it at all. That's probably a good one. Anybody else have something? All right. Well,
Well,
since
I just wanted to say that my problem with dual agency is the actual term. Because as soon as you become a dual agent, and I'm not sure even a lot of realtors that we end up dealing with understand this, but once you are a dual agent, you are not able to give the kind of agency representation, the agency advice, the fiduciary duty to either party.
yeah, yeah,
You're
it's
more of a mediator. You're not an advisor. You're not an agent anymore. You're a mediator
yeah,
if you're a dual agent.
you become your role becomes ministerial.
Yeah, so I don't know why we're getting paid the same amount when we're not acting as an agent and we can't guide them.
Yeah.
I'm a broken record on this one, but
Yeah, yeah. No, I hear you, and there are valid arguments for that position as well. Yeah, but there's equally bad reasons to avoid having an unrepresented side as well in a transaction. And in my opinion, the two scenarios, either being dual agent or being unrepresented, is also has equal or greater risks, in my opinion. And so it's always better to refer it out if possible. And Andrew's policy has always been to, he has not said that we can't do dual agency, but he really wants to discourage it. So unless anybody else has any other thoughts, comments, or opinions, let's thank you for joining us and hit the road, and we will make some money today.
Thank you.
Thank you.
All
Thank
right.
you.
Good luck
Take
with your
care.
dad.
Okay,
Thank
thanks.
you.
All right, bye.
Yep, bye.